All right, so welcome to our May 2022 Lunch and Learn. Our topic is expungements. I know several CASAs have experiences when some youth encounter some juvenile justice issues, and one of the things that CASAs wanted to learn more about was expungements. So I asked Liz Fillingame, who is a deputy child attorney, to chat with us about that, about expungements, and teach us about them. So Liz, I'll turn it right over to you.
All right, thanks, Lauren. So like Lauren said, I am one of the deputy child advocates, and I actually manage all the expungement stuff and juvenile justice stuff for all of the OCA clients. So we'll talk a little bit about what that means as we go through. So let's start with what is an expungement. It is the process by which a criminal record is erased or sealed. And the reason I say erased or sealed is because those are two different things when we start talking about legal definitions and what they mean. So in Delaware, for juvenile offenses, it is really erased, meaning it goes away. It doesn't just stay somewhere in a database. When a juvenile record is expunged, if someone goes to run it, it's gone, and it's not sitting somewhere in a file like some states do, waiting to be reinstated if they pick up additional charges. Delaware doesn't work that way. So when we talk about expunging a criminal record for a juvenile in Delaware, it really is completely gone. So that's the other part to this that I want you to keep in mind as we go through today. We are talking specifically about juvenile expungements. Adult expungements are different, and it's not something that we handle in-house. However, if we had a youth that was on extended jurisdiction, right, so they've turned 18, that needed an adult expungement, we would refer them to the Office of Defense Services to get that done. But that's not what we're going to focus on today. We're going to focus on juvenile expungements. So what are the types of expungements? There are two. There's mandatory expungements, which means a youth is entitled to an expungement and the court must grant it. We do not have to serve the Attorney General. And so that's important because it's not, the court doesn't have the choice to grant it. They are statutorily entitled to it if they meet certain requirements. And then there's a discretionary expungement. So youth may apply for an expungement, but the court has the discretion to grant it or not. We have to serve the Attorney General when we file this expungement petition, and the Attorney General gets to take a position on that expungement. So usually what happens if we file a discretionary expungement, the Attorney General's office will respond. They either support it or they don't support it. They oppose it. And if they support it, then generally the court is just going to sign off on it, although they don't have to. They could require a hearing. If the Attorney General's office is going to oppose it, then there's going to be a hearing, and the two sides are going to come in and explain, why the kid should get an expungement, why the Attorney General's office is going to say why they oppose it, and then ultimately the court would have to make a decision. Questions about expungements and the different types before we move on?
What would be a reason for a discretionary expungement? What kind of criminal record does a youth need to have for it to?
Glad you asked that question. So before we get right to that, we're going to talk about who's eligible for an expungement in general, and then we'll kind of go into the breakdown. Okay. So who's eligible for an expungement? A juvenile who has charges and those charges have resolved somehow and they have no current active warrants, right? So if a youth has charges and they're pending, that means the court hasn't resolved them yet. And so we don't know yet what kind of expungement they would be eligible for. So we can't do anything with that. If they have charges that have resolved, and so you look at their Delgis summary and they have no pending charges, but they have a warrant out for something, they're also not eligible because we have to wait now for that process to take place, them to be picked up, to be processed, to be charged, ultimately for that charge to work through the system. So they have to have resolved charges and no pending warrants. So that's for a juvenile. And then an adult who only has charges from prior to turning 18, The charges have resolved, and again, there's no active warrants. So it is possible for an adult to qualify for a juvenile expungement if the only charges on their record are from before they turned 18. So when is a youth eligible? A youth is eligible for a mandatory expungement if only misdemeanors and violations were terminated in favor of the child. So that means they were only charged with misdemeanors or a civil violation, which doesn't even meet that threshold of a criminal charge. And they were terminated in favor of the child. So that means dismissed, nollie-prossed, could mean they went to trial and ultimately the judge found state didn't meet its burden. Can also mean probation before judgment, or PBJ. Those are all considered things that are terminated in favor of the child. So that's one way to get to qualify for a mandatory expungement. Misdemeanors and violations terminated in favor of the child. Or only felony and misdemeanors violations terminated in favor of the child, and a year has passed since the last felony was terminated in favor of the child. So if it's only misdemeanors and violations, it's immediate. On the day that the charges resolve, the youth is eligible for a mandatory expungement. If they were also charged with a felony, then it's not immediate on the day that the charges resolve. They have to wait a year to qualify for a mandatory expungement, even if it was terminated in their favor, because it was that higher level felony charge. Or no more than one felony, misdemeanor, or violation. So if they only have one charge that results in an adjudication, right? And that's what we call a conviction in juvenile terms. So no more than one adjudication, and 3 years have passed since that adjudication, they would potentially qualify for a mandatory expungement, but not if that adjudication was a violent felony, a felony sex offense, or a misdemeanor sex offense. So as we go through these, even though I've tried to simplify them as much as I can, you can tell we're already kind of getting down in the weeds about legal terms. I wanted you guys to have a sense of the analysis that I go through when I am determining if a youth is eligible for an expungement. But the good news is you guys don't have to know how to do this, because that's my job to do it. And then let someone else know, typically the coordinator and the attorney, and we'll talk about that in a few minutes, that the youth is eligible for an expungement. But I do want you guys to at least have been exposed to when a child is eligible for one, okay? And there is something called a sua sponte expungement. This came about just a couple years ago, and it says that the court can waive the 1 year requirement for a felony terminated in the child's favor. So what does this look like in practice? If a youth and their public defender or potentially private attorney are at a criminal hearing and the charges resolve in the child's favor, even if a felony is included in that, the attorney can stand up and say, Your Honor, I'm moving for you to expunge the record now, as opposed to anyone having to file something written. And the court can, under this statute, if they choose to, waive that 1 year requirement for a felony. They do not have to, completely within the court's discretion. If the public defender does not, for whatever reason, stand up and make that motion, the court can also do this, what we call sua sponte, meaning of their own accord. They can just go ahead and decide to do this if they choose to do it, even if an attorney doesn't make that oral motion. And we are seeing sua sponte expungements a whole lot more than we have seen them in the past. And this is great because it means we don't have to go through the process of charges resolve. I screen kids about every 60 days, meaning I have a whole list of all the youth that are 11 and up in Delaware that have picked up charges at one point or another. And I touch on every kid about every 60 days. So the good news, when the court does these sua sponte, is that we're not waiting for me to come around to that kid on my list again. and then reach out to the child attorney and the coordinator and say, this kid is eligible, and going through that whole process, then filing the paperwork. So it's much, much faster, which is great for our youth who are, potentially applying for jobs and applying for colleges, and we don't want these things on their record. All right, so that's mandatory. Discretionary expungements. A youth is eligible for a discretionary expungement if there is a felony misdemeanor violation terminated in favor of the child and less than a year has passed, right? So when we got that felony charge in there for a mandatory expungement, it had to be more than a year had passed. If it's less than a year, we can file for an expungement, but we have to file a discretionary petition as opposed to a mandatory petition, which then again means we have to serve the Attorney General and they have the chance to weigh in. A single case that resulted in an adjudication of delinquency for a misdemeanor sex offense or a violent felony, and 3 years have passed. So this is where we really start to get down in the weeds. It's very charge specific and time specific. And when we say 3 years have passed, it is 3 years from when the charge resolved, not 3 years from when the charge occurred. And that can be significant because for a youth that picks up a lot of charges, they could have picked up charges in 2018, 2019, and those charges didn't resolve until, with COVID, 2022. It doesn't go by those 2018, 2019 dates as to when they're eligible for that expungement. It goes by the date it resolved. So it would have been 2022. And then that 3 years starts running. No more than one case adjudication for a felony sex offense and 5 years have passed qualifies for a discretionary expungement. We can have multiple adjudications for cases except violent felonies and felony sex offenses, and 5 years have passed. So this was a change a few years ago. Youth that had a ton of charges would not qualify after they had so many adjudications. The way the statute was amended now says, even if they have multiple adjudications, they can still qualify, but the time period they have to wait is longer. So if it does not include, if their adjudications do not include violent felonies or felony sex offenses, then they have to wait 5 years. If their adjudications include violent felonies or felony sex offenses, then they have to wait 7 years. And 7 years is the maximum that they would have to wait to qualify. That was a ton of information. Does anybody have questions about that?
We
Yes.
do. Joyce has one.
Okay.
When you say adjudication, can you explain that as opposed to charges?
So charges are what happens when they're initially charged, right? Just because they're charged doesn't mean they are guilty.
Mhm.
We use adjudication instead of guilty because we're talking about juveniles. So we don't use the term guilty or conviction. We use the term adjudication. So that's really just when the court has made a decision about those charges.
Okay.
What qualifies as a felony sex offense?
So that is by statute, and there's a really long laundry list. Typically, it's going to be your rape 1, rape 2, unlawful sexual contact 1, like those higher level charges. And then the lower levels, like unlawful sexual contact 4, is going to be a misdemeanor.
I have a question. If we look at number 4 and number 5, so those multiple adjudication for cases, 5 years have passed as of date of the case was resolved in court. And then number 5 is 7 years after the case has been resolved. So that means most of the time that the child will be over 18 years
Yes.
of age, and they still can be discretionary expunged, those cases, even though the child is then an adult.
Correct. They still have to wait those 7 years. So this is really unfortunate, right? When, excuse me, when we have a youth at 17 who is adjudicated of, say it's a violent felony. if they're adjudicated at 17, they're not going to qualify for an expungement until 25.
Mhm.
And if they pick up any charges, we'll talk about this more in a minute, but if they pick up any charges post 18
Mhm.
and they're convicted, because they're an adult then, so they would be convicted, then they no longer qualify for a juvenile expungement at all. Yeah. Any other questions?
Yeah. So for the mandatory expungement, so who makes, so if it's mandatory, but who makes sure, like, do you make sure that it happens if they don't have someone advocate, paying attention, advocating, requesting it? So
I do. So we'll talk about that too. But yes, ultimately it is my job to notify the attorney and the coordinator and let them know that a youth is eligible and that they need to file that petition essentially.
All this is done in the family court?
Yes.
And so when you say you have to, the attorney general, you have to file with the attorney general, that doesn't go to a higher court, that's just with the state attorney general's office?
Correct. Yep. So there's a juvenile criminal unit or juvenile delinquency unit within the attorney general's office, and those attorneys handle these types of cases.
In the family court?
So the hearing is in the family court. The attorney general's office is, is separate, but yeah.
Okay.
Yep. All right. So when is a youth not eligible for an expungement? If they have an adult conviction. So once they pick up a conviction post 18, they are no longer eligible for a juvenile expungement ever. And that's something that we really try to impress upon our youth, that we know we're going to qualify after they turn 18 at some point. We really try to impress upon them, listen, you think life is hard right now because you can't get this job you want, or you can't get into this school you want. But in a couple years, that situation could change when you're eligible for this expungement, unless you pick up more charges, because then we can't ever get rid of it. Again, if they have pending charges or an active warrant, they're not eligible for an expungement until those resolve. And if they only have Title 21 charges, which is typical motor vehicle charges, so speeding, different moving violations, you can't expunge those. Those are just considered kind of run of the mill, and they're not going to qualify for an expungement. The exception to that is a felony DUI. If they get a felony DUI and they're under 18, that can qualify for an expungement.
Awesome. Ashala has a question. So Ashala,
Sure.
you go for it.
Thank you. Okay, so really quick question. Who contacts or keeps in touch with the child as this process is ongoing? I know you said it can take 7 years. There are so many changes that can happen. I'm not legal. My mind is not where you are. So
Yeah,
I don't
unfortunately,
know
nobody.
Yeah, that's what I wanted to know.
Yeah, so best practice, I'm going to show you the email that I typically send to the child attorney and the coordinator in a few more slides. And it's got the information that tells them what kind of expungement they qualify for, the date they qualify for it, and why they qualify for it. Best practice is to give the youth a copy of that, either when they turn 18 or are aging out, or when they finish extended jurisdiction, and just say, try to impress upon them the importance of this. Hey, this is really important. When you get to this date, if you haven't picked up any new charges or convictions, really, you're going to qualify for an expungement. And while I won't be your attorney then, so I can't help you with it, you can go to the Office of Defense Services, and they run free expungement clinics, and they'll help you do this. Do they follow through? Probably not. But it's really the best we can do when we no longer represent them.
Thank you. And are the parents, I'm just trying to get a sense of what happens here, but are the parents actively involved? Like, I don't know what the ratio would be for those that get it and those that don't understand the severity of the situation. But I feel like, I don't know, we're talking about children here. So legal terms, understanding consequences, I know some of these children or teenagers specifically are more mature and probably can grasp it. But I've got two little ones myself, and they're not street hardened. So I don't know
Right.
if they would understand any of what you just said in that letter.
Yeah. It's, there's no good answer to that. I mean, some of them get it, some of them don't. If you have a case that ends in reunification or guardianship, then you could absolutely include the adult that's in the kid's life in this information, right? But it's the ones who age out or finish extended jurisdiction, and they don't really have that adult figure. The only thing we can do is communicate it to them the best we can, and hope that they follow through.
Thank you.
Yep. All right. And then they also don't qualify for an expungement if they have an adjudication for first degree murder, second degree murder, first degree kidnapping, manslaughter, rape first, rape second, or any attempt to commit the above crimes. And so that is an exhaustive list. It is those 6 and attempted of those 6. If they have an adjudication for those, they do not qualify for a juvenile expungement, period. All right, so how do you know if your youth is eligible for an expungement? OCA, and by OCA, I really mean me, screens every youth aged 11 and up, and we set it at 11 because that is the minimum age at which children in Delaware can be charged criminally. So we screen every youth aged 11 and up for juvenile justice involvement. We do this through our database, which is called Apricot. So I do this at 3 separate time periods. When they enter care, if they are 11 or older at the time they enter care, they automatically get screened then. So we at least have a baseline. Do they have charges or do they not? And if they already do, what do we need to do about it? If they've already entered care prior to 11, then when they turn 11, they pop up on a list for me. So I know to screen them initially and get that baseline again. And then we also coordinate with the Office of Defense Services. They actually send us an information dump every day that goes to our data team, and they scan that list. So the Office of Defense Services sends us a list of every new client that they get assigned every day that's a juvenile. And we then in-house, not me, this is our data team, screens that list to see which of our clients show up on it. And our data team enters that into the database and it pops up on a list for me to say, hey, this kid just picked up charges. And so then I go and run their DELGIS and track it that way. So at those 3 points in time, kids get screened. And in theory, we should be catching every child that picks up charges that way. Data is imperfect, right? If someone at the public defender's office leaves a name off the list or it doesn't come through for whatever reason. I have seen kids pick up charges that were not on my lists. It doesn't happen frequently, but no system is perfect. So that's our attempt to kind of catch as much as we can. But that's kind of where you guys come involved. And one of the reasons that we wanted to kind of share this topic is so that you guys are aware this is something that we offer. But you're the expert on your client, right? You're the expert on your youth. So if you think that they have picked up charges or you know that they've picked up charges and you think they have resolved and you haven't heard anything about an expungement, by all means, well, reach out and I can always run it and see if, something happened and it got missed somewhere.
Based on the youth not being eligible, and I look at you deal with youth 11 or older. If a youth is charged, I don't know if that happens in Delaware, but can a youth be charged as an adult based on the crimes committed?
They can. And that's really complicated. I wasn't gonna get into that today, but yes, they can. It's something called an amenability hearing that has to happen in family court. So if the Attorney General's office wants to charge a juvenile as an adult, they have to have an amenability hearing before a family court judge and explain why essentially they want to charge as an adult and why they think that's appropriate. And then the family court will make a determination as to whether or not that child is, quote, amenable to rehabilitative services. That's where that name comes from, amenability hearing. If the family court finds that the child is amenable to being rehabilitated, then they will deny the motion to charge them as an adult, because our whole purpose in the juvenile system is to rehabilitate youth.
Mhm.
Whereas the adult system, well, in theory is somewhat rehabilitative, is really more punitive.
Mhm.
And so the court has to make that determination, but it is possible in Delaware. Yeah. All right. So if your client is eligible for an expungement, then the child attorney and the coordinator get an email from me. And this is what that email looks like. So this is for a discretionary expungement. And it tells them, you know, the type of expungement they're eligible for, the date they were eligible. It's got an explanation. So the format got a little bit messed up when I copy and pasted this into PowerPoint. Usually these lines underneath where it says explanation have bullet points, and I highlight the one that is relevant to this particular youth so that they know, you know, and they also know how long they have to wait from that eligible date. And then it gives them some directions, right? It tells them that this is where you can find the forms. There is no fee to file the petition. They have to get a certified copy of the youth's criminal record. So even though coordinators have access to JELGIS and can see their criminal history, that's not sufficient. The youth has to be taken to be fingerprinted. If the youth is under 18 and DFS holds custody, DFS has to be the one to take them. No one else can take them. And so typically DFS will pay the fee for fingerprinting, which is $52.50. Occasionally we get pushback from a DFS worker who doesn't think the youth, quote, deserves it. And instead of fighting with them about it, it is just easier for us to pay it, and we will pay it to get that done. Because it can drag on for months and months. And if the worker doesn't want to pay it, it's just easier for us to do it to get the process moving. So it tells them DFS has to take them to get them fingerprinted. If the youth is over 18, obviously they can go themselves. They may need some support person with them to help them get through the process, but they can go themselves. The certified criminal history then gets mailed to someone. They don't leave with it that day. I always encourage the attorney to specifically ask the DFS worker to have that certified criminal history mailed directly to the attorney, because you have to file the expungement petition within 45 days of the date on the criminal history. Otherwise, we have to start the whole process over again. And we've had it happen before where the DFS worker had it sent to them, they didn't get it to the attorney in time, and then it was no longer good. So best practice is for it to just go directly to the attorney's office. And that way we don't have to, you know, constantly harass the worker for it and worry about it not getting filed in time. So that's a discretionary one. The mandatory one is almost exactly the same. The language is all the same, except up top under the explanation. And again, I highlight why they qualify for it. So best practice is to print out this letter and give it to the client if we know we're not going to be able to file it on their behalf because we're not going to be their attorney by the time they qualify, right? And then, you know, again, what they do with it is really up to them. But at least they've been given something that tells them what to do and how to do it and when to do it. All right, so how can you, as the CASA, help? If you know that your youth has charges, you can ask the coordinator to run a DELGIS report about every 60 days. I mean, you could ask them to do it more often to check the status. I'm doing this too, but you can also do it, right? If you aren't sure if your youth has charges, you can ask the coordinator to run that initial DELGIS report just to kind of to check. And then if the youth has charges, are they addressing those behaviors that led to changes in therapy, right? We can communicate this information with the therapist. Hey, Susie picked up 10 charges for offensive touching over a month-long period. Clearly something's going on. Did you know about this, therapist? Are you talking about it, right? So just making sure that information is being shared. All right, so I wanted to go through a few examples. Susie is charged with offensive touching, which is a misdemeanor, and disorderly conduct, which is also a misdemeanor, on October 30th, 2021, for a fight she got into at school. She's assigned a public defender. Her charges are dropped on March 3rd, 2022, at a case review hearing. However, the charges are still showing on her Delgis summary. So Susie is eligible for a mandatory expungement. Why?
It's 45, because the charges were dropped.
Because the charges were dropped, yep. Why else?
She's within the window of time that you have to, well, I guess you said it's a misdemeanor, right?
Yep, and
Right.
it was a misdemeanor, so that's what's really important here. It was dropped and it was a misdemeanor, so she's eligible for a mandatory expungement. She's only got misdemeanor charges. They were terminated in her favor because they were dropped. And so she is immediately eligible for an expungement. She does not have to wait at all. What if the charges had been felonies and then terminated in her favor? Then she's still eligible for a mandatory expungement, but it's 1 year from the resolution date, or she could file a discretionary expungement immediately. Sometimes what we'll do as attorneys, if like we have this situation where it was a felony, we'll reach out to the Attorney General's office and try to get a hold of the prosecuting attorney who prosecuted the case and say, listen, I could wait a year, but I'd rather file it now. Would you oppose it? And if they say they won't oppose it, then we may just go ahead and file that discretionary. If they tell us they're going to oppose it, we may still file it anyway and fight it, or we may decide it's not worthwhile to fight that and to just wait the year, depending on what the specific situation is.
And what would be some of the reasons they may oppose it?
They might oppose it because there's a whole host of reasons. They really think she did it. The only reason they dropped the charges is because a witness didn't show up. There could be a whole host of reasons that they would oppose it. Where they really kind of dig their heels in typically are kids who have picked up multiple adjudications. And so there's a pattern there, and they might say something like, we would oppose it because instead of only waiting 3 years, we think it's more appropriate to wait 5 years or whatever it may be. But yeah, there could be really any reason that they come up with they could oppose it for.
But the charges have been dropped and, because it's a felony, that's the difference.
Right, because it's a felony. Yeah.
Mhm.
And so you'd have to wait that 1 year. Once you get to that 1 year mark, then it becomes mandatory.
Mhm.
So then they can't oppose it anyway.
Okay.
I don't know I can't think off the top of my head of a good reason why they would oppose, except for they really think she did it, but the witness wouldn't cooperate.
Ask a quick question.
Sure.
In the example that you just gave, if you proceeded with a discretionary expungement and failed in that attempt, would that or could that have an impact on the mandatory expungement at the end of a year?
Nope.
Okay.
Yeah, it's just, frankly, it's a matter of resources, right?
Yep.
So the attorney may make the determination, like if it's a 16-year-old and they're still going to be representing them a year from now at 17, or they're likely still going to be representing them a year from now at 17. If the Attorney General's office says they're going to oppose it, the attorney may just make the decision not to fight it strictly on resources. How much time am I going to put in this when I'm just going to turn around and get it anyway in a year?
Yep. Makes sense. Thank you.
Yep. All right. So another example, Johnny's charged with multiple misdemeanors and felonies as a result of multiple incidents over a 6-month period. After about a year, all of his charges resolve. Some of his charges are dropped, but he is adjudicated for offensive touching, which is a misdemeanor, and assault second, which is a violent felony. and possession of a deadly weapon during the commission of a felony, which is also a violent felony. And those charges resolve on January 5th, 2022. So Johnny is eligible for a discretionary expungement, but why? Because he has multiple adjudications, which means a mandatory expungement is not on the table at all, right? We know that right off the bat. Mandatory expungement's not on the table because he has multiple adjudications. Multiple adjudications means we're either looking at 5 or 7 years from the date the charge is resolved under that structure we kind of went through before. Because he has adjudications for violent felonies, he has to wait 7 years before being eligible for an expungement. If they weren't violent felonies, it would be 5 years. However, if he picks up new adjudications before those 7 years are up, then the time starts again. If he picks up new convictions post 18, then he's no longer eligible for a juvenile expungement at all. Right? So let's say these original charges from the adjudications from January 5th, 2022, let's say he was only 14 when he got those, right? And then he's good for 2 years. He doesn't have any other issues, hasn't picked up any new charges, but he doesn't qualify for 7 years. And then when he's 16, he picks up another charge and ultimately is adjudicated. At that point, his 7 years starts over. Right. So, it's not ideal, but the idea is the more serious the crime is that they've been adjudicated for, we want to really see that they are rehabilitated before we wipe out that criminal record. Because if you remember, in Delaware, it completely goes away. It's not just sealed and can be reopened. So, yeah.
But even during this time, that 7-year period, this is affecting credit, applications, work, all this stuff, right? All those things that would be part of rehabilitation.
It is. And it's not often that we see really serious charges like this stick the first time around. We'll often see them pled down so that they're not in that situation. However, occasionally, whatever situation a youth may have gotten into is so bad that those charges do stick the first time around. Okay. But youth are in family court, so they're still getting the benefit of these family court judges as opposed to CCP or Court of Common Pleas or Superior Court judges. So they're still kind of in that family-friendly, youth-centered environment, which is helpful. And the judges do kind of push back, generally speaking, on really severe sentences for youth. But occasionally we do run into situations that are just so bad that it is warranted and there isn't really a way around it.
So if the charges have been pled down, then on the record are noted not the initial charges, but the charges that he admitted to or pled down to. Mm-hmm. Okay.
So a criminal record would say charged with, let's say, rape first, and then adjudicated for unlawful sexual contact fourth. So it does show what they were originally charged with and ultimately what they were adjudicated for. So if someone runs their criminal history, they're going to see both. However, for purposes of expungement, it goes by what they were adjudicated, not what they were charged with.
Okay.
Yeah.
Does any employer or potential employer have access to Delgis to be able to find out if they've been in trouble?
I don't think they have access to Delgis. I think they can require that a youth go get fingerprinted and then they get the actual certified criminal history. But I don't think employers, generally speaking, have access to Delgis. I think that is just a state system that certain state workers have access to.
Is it difficult for the employers to go through the fingerprinting process and find out about a potential employee?
It is not. And it does bar some of our youth from, getting jobs, getting into school. Yeah.
How does some of this work with drug charges, something like that?
It's the same.
It's the same?
Yeah. They're charged under the criminal code. And so we frequently get possession charges or drug paraphernalia charges, probably one of the most common charges that our youth pick up. However, in Delaware, the law was changed in the last couple of years so that a certain amount of marijuana isn't a criminal charge. It is a violation. It's considered a civil violation, and they pay a fine. That does still show on their record, though. All right, so example 3, a youth is not eligible. So Adam is charged with multiple counts of rape first. Multiple counts are dismissed, but ultimately he is adjudicated for 1 count of rape second, which is a felony. Adam is not eligible for an expungement at all. Why? Because that was on our exhaustive list, right? That rape second. So no adjudication, no expungement, because he has adjudicated for that particular charge. What if he was adjudicated for unlawful sexual contact second, which is also a felony? Then he is eligible for an expungement, because after either 5 or 7 years, depending on whether or not the adjudication was considered violent. And so here, a public defender who is really doing their job is going to advocate, like, you can still charge my client with a felony, right? That's fine. Charge him with a felony. It was significant, but charge him or convict, we'll take a plea deal to unlawful sexual contact second, as opposed to rape second, because we know that we can get that expunged down the road, right? So a public defender who is really kind of advocating for their client will be advocating in that kind of capacity.
If a teen is convicted of unlawful sexual conduct or a rape, are they on the sex offenders list too, automatically?
Yes, for certain charges that automatically get you on the registry. Yeah, and it doesn't matter if you're juvenile or not.
And if it is going to be expunged, will he be or she be taken off the sex offenders list?
The sex offender list is completely separate from expungements.
Okay.
Some charges, some adjudications, you can come off of the registry after a certain amount of time, and it's automatic. You automatically come off. Some you can never come off. Yeah.
So that also means that they have to be registered as a sex offender if they're looking for housing and anything else.
Correct. If they're required to register, yes.
Yeah. Okay.
Yeah. All right. That is my presentation. What questions do you guys have?
Can you show that list of no expungement if they adjudicated for, I think you had a.
Yeah. This one?
Oh, okay, the 1st degree manslaughter, okay. Okay.
Yeah, it's those really bad charges. We don't see them very often. Probably count on 2 hands the number of times I've seen the adjudications for those charges for any youth in care in the last 7 years, but occasionally it does happen.
Okay.
Liz, would you be okay if I shared this PowerPoint in a PDF format with our CASAs?
Sure.
Okay.
Oh, I do just want to add one thing. So we talked a lot about kind of how, what all this means. We have to be very, very careful when a youth is represented by the Office of Defense Services, not to involve ourselves in that representation in any way. So while we might be tempted to advocate like for that unlawful sexual contact charge instead of that rape second charge, we really cannot involve ourselves in that representation. Other than making sure they have an attorney, we really cannot be involved in that.
Can you talk a little bit more about like the child attorney's role? Well, I guess the triad, like while the criminal hearing is kind of going on. I know this is kind of pre-expungement, but like while that's happening.
Yeah, so our main role is to make sure that when we know a youth has charges, that they get a public defender and that public defender is meeting with them. And so sometimes we can see who the assigned public defender is in Delgis. Sometimes we can't. But DFS workers should certainly know who the public defender is if no one else does. You can also reach out to really to me, and I could reach out to someone at the Office of Defense Services if you're having a hard time figuring out who their public defender is. But we can do a couple things. One, make sure they have one. And two, make sure they know our client's story, right? We want to get them invested. So while we can't interfere really in any way in the representation itself, we can certainly give them all kinds of background information on our client that might make them just want to work a little harder for this kid as opposed to the 200 other people on their caseload, right? Or might make them a little bit more sympathetic to our client who has picked up 15 offensive touching charges against law enforcement and teachers and peers. The public defender might be a little more sympathetic and want to advocate harder for your mutual client if they know that there was a finding of abuse and your client was the victim, right? Just things like that, information like that, that background information that we can use to pull in the public defender. So we can share information, we just can't involve ourselves in their criminal representation. Does that kind of answer your question, Lauren?
Yeah, that's actually really great because then it kind of touches on confidentiality, because one of the things that CASAs we drill during pre-service training and just training in general is about confidentiality. Like, you don't tell anybody anything.
Yeah.
Information gatherer rather than share, but it's helpful to know that we can share specific information with the defense team for our mutual client.
And I wouldn't advocate for the CASA to do that on their own, but certainly I think having that conversation within the triad and making sure the child attorney is okay with it. I know in my cases, I would probably want to have that conversation directly with the public defender and potentially involve the CASA in that conversation as well. I don't know how other child attorneys would necessarily want to handle it. So I think you start that conversation within the triad and then figure out how and who is going to communicate the relevant information to the public defender.
Yeah, that makes sense. And then it makes sense kind of linking attorney to attorney, but having that kind of prep discussion within the triad, especially if a CASA feels that the alleged crimes that the child is committing stem from parts of their story, kind of like the example you just gave. So
exactly.
Yeah.
Or, if we have a kid that's been charged with tons of shoplifting and we find out it was for necessities as opposed to a video game, right? Things like that. Just, it may be helpful for the public defender to understand, when this was happening, this kid was living in a hotel room with an addict parent who was not providing their basic necessities, right? Any other questions I can answer? And if anyone has any case specific questions, I'm happy to answer those now. We would just need to go off the recording.
Is our coordinator the third person in the triad other than the lawyer?
Yes.
Good.
Yep. So you remember we got our triad, we've got our CASA volunteer, our CASA coordinator, and our child attorney, kind of in that little triangle with the child in the middle. So really most of our discussions on any particular case is going to involve your triad on a regular basis. So you should be chatting with your CASA coordinator about pretty much anything and everything. And then that coordinator can decide kind of when the attorney needs to know certain things. And I'm not saying the attorney shouldn't know everything. I'm just trying to think, the attorney has quite a large caseload. So they may not need to know about every single visit or every single, appointment, but maybe some things that are significant where the child attorney can take some action, especially when it comes to working with another attorney.
Mm-hmm.
Awesome, everybody. Well, thank you so much for attending today. I really appreciate it. And I will record your 1 hour of training credit.